Welcome back. Thank you so much for joining us. I have a feeling that this Oscar Pistorius story is going to dominate not only headlines, but office politics. I imagine people around the water cooler discussing it here on set, on floor, behind the scenes. We're also debating it, and suddenly everybody's a legal expert. So we all have opinions. But if you have missed the story, Oscar Pistorius was granted bail of 10,000 Rand yesterday at the North Gauteng High Court. The state did not oppose bail, but it was confirmed that Pistorius and his legal team will be applying for appeal on his murder conviction at the Constitutional Court. Well, the case has been postponed until the 18th of April next year. We're joined once again by legal expert Michael Motsoeneng Bill from Motsoeneng Bill Attorneys. It's great that you could stay on with us because, as you've just heard from the crew here on floor, there's a lot to discuss. Let's now speak about Judge Masipa. That's where we left off. Yeah. The questions are being asked whether or not she should recuse herself from this case. What do you think?
Absolutely not. You got to remember, and one can't emphasize this enough, Judge Masipa had erred, according to the Supreme Court of Appeal, on a matter of law. Judge Masipa is nevertheless, despite that, one of our best judges in the world. So she's a competent judge. The Supreme Court of Appeal is very loath to give compliments to judges. You don't see that happening. They've complimented her. They've commented on her professionality and the manner in which she's handled this matter. The fact that you don't agree, the fact that we don't agree, as lawyers, we're not supposed to agree. It's a good thing when we don't agree. If you have a jurisdiction where everybody agrees all the time, you will at some point start asking yourself, who's thinking here? It follows. I've said that the Supreme Court of Appeal itself has difference of opinion on some matters. This one is unique in the sense that they were all unanimous. The Constitutional Court itself has dissenting judgments, where of all the judges on the bench, 2 will say, actually, we don't agree with the majority judgment. That does not mean that these 2 dissenting judges are for one or other reason not competent, or that gives a basis for them to recuse themselves. All it means is that we're all thinking and we all don't agree. And what it does, and that's why law is such a beautiful thing and such an honor to practice law, is because you in future can say, hang on, in this matter, the minority judgment was the following. In fact, I think that the minority were actually right. And you could use that to bolster your argument at some later stage. Whether the next court agrees with you or not is something else. But that's the beauty of law, is that everybody who renders judgment, in this judgment we had only one judge who rendered the judgment. All of them were just saying they agreed. When you have all those, when they have the benefit of all those thinkers, it enriches the law. It makes it so rich that for people who study law and who practice law, they are able to create arguments and explore. You know, the fact that Beru today is sitting and saying he's going to bring on behalf of Oscar Pistorius an appeal to the Constitutional Court. I can't imagine on what ground, what plausible ground he would bring it. But the fact that he does, and he has imagined a reason, is a very interesting thing on its own. And one that should be tested. Because he wants to test something that I didn't even conceive. Of course, I conceive 1 or 2, but I think they're not so plausible that he would actually proceed with them. But I look forward to say, what is he going to say? And that's the beauty of law, but that's the beauty of justice. And you know, as somebody who is subject to justice system, either as a victim or as the accused person, you know that there's always room for your voice to be heard. And think about it. The fact that he's going to the Constitutional Court, that on its own, viewed for what it truly is an opportunity for Oscar Pistorius to be given one more chance to be heard.
And now let's talk about Judge Masipa, stay with her, but discuss a little bit about the fact that this was so high profile. Was a catch-22 for her. It was a bit of a bittersweet, because people are now turning around and saying, how could she have made such an error of law when, you know, on a daily basis, judges have their judgments overturned by the Supreme Court of Appeal and other higher jurisdiction or bodies. But let's speak a little bit about the statistics there, maybe like a ballpark figure. Do judges often have their judgments overturned?
Absolutely. That's why you have, of course, it's not every appeal that's entertained. So appeal courts are loath. They don't just you don't just say, I want to appeal, and they say, please, you're welcome. They look at your grounds, and only once they believe that there's a reasonable prospect of some kind of success. And this is not, it's a different test from whether you'll win or not. It's just saying, when we look at this, are there some prospects that he can persuade us on this point? And if your grounds of appeal are so remote that they don't think that you will win, then they won't look at it at all. So there are many people who appeal. Not all of them are granted leave to appeal. There are even much more people who actually do appeal and have the appeals overturned. But
there's one school of thought that would suggest that, the law belongs to the rich, or it favors the rich in one way or another. Do you think Oscar Pistorius has been given preferential treatment?
I would submit quite the opposite. I think he was not given any advantage at all. In fact, we've heard that from having afforded a bail of R1 million and to issue a guarantee of R1 million, he now has to make arrangements to pay 10,000 rands. Now, quite clearly, what this has demonstrated is that there are free legal services available that are provided for by the state. If you have your own funds, by all means, go that route. But it's not for the rich, because he has suffered. The fact that he's gone from being a millionaire to having to make arrangements to pay 10,000 rand, that on its own is suffering. And if we then apply that same rationale that justice is for the rich, then perhaps we should look at what's going to be happening in the Constitutional Court, because now we know that he doesn't have money. And Berry was very eager to make the point that he can't afford that money. Mm-hmm. So I think, of course, that's something we can never completely cure. So to be fair to your question, when you are rich, it means you are in a position to choose who must represent you. So that the ability to choose is in itself an advantage over somebody who doesn't choose, because what it means is that you choose your own horse for your course.
But he may be in financial dire straits, but he has a certain element of privilege. I mean, the spotlight that's on him, do you think that's a good or a bad thing? Do you think, no?
I wouldn't look at that as privilege at all.
Yeah.
I wouldn't look at that as privilege at all, because if you think about his first release from prison, when it was decided, when his release was decided prematurely, and I must say the Minister of Justice was very quick and reacted very well to correct that and have him go back, because it was prematurely considered. If he wasn't as famous as he was, that would never have come to the attention of the minister. It would have just slipped off, and so that is an example of how the spotlight has been contrary to his interest. And has not worked for him. In fact, I can't imagine that in the history of this trial there was ever a situation where he's gained an advantage by virtue of having all this attention.
Okay, for now, for the purposes of time, I'll rest my case and concede to you just a little bit. But very quickly and briefly, questions are being asked about our judicial system and whether or not perhaps we should borrow from countries like the US and do the jury system.
Yeah.
What would you say?
I'd say the US and all of those countries must borrow from our system, because what you've seen in this trial and what we see as practitioners, the richness of our justice system is such that when they look at this, and I tell you, if anybody actually interviewed any of them and asked them, what do you think of this? The answer will probably be, this has been sterling, and it's second to none. If I were to look at the justice system in America, I would say they should look at what we're doing here. It's not that we never had a jury system. We did have a jury system. We cancelled it for good reason. You asking me questions now about Judge Masipa and how her personal views might have interfered with this. Can you imagine how much more that question would arise if it was just lay people who had no principles of law to guide them?
Good. Food for thought that you leave us with. I've thoroughly enjoyed this conversation. Thank you so much for your time. Michael Motsoeneng Bill from Motsoeneng Bill Attorneys. I trust you've also enjoyed this conversation. It will give you a little bit of ammunition when you go speak to your friends about the case, right? A quick ad break. We continue after this. Stay with us.